All right, family. This is module 3, and not this whole module, but this particular page that we're going to go over here right now. This is where trust law gets a little slick. Okay, but I got you. Now, we discussed earlier, let's get back to it, the express trust, the implied trust. Okay, we discussed that already. So now we're going to go to the breakdown of exactly what circumstances create an express trust and what circumstances create an implied trust. This is not all inclusive, but it is the basic principle of each type. And I want you to just clear your mind because, like I said, it gets a little tricky here. What I'm going to go over is not only implied trust, but implied consent. Because though implied consent is not necessarily something that trust law dictates that you study, I feel that they go hand in hand. And if you don't know one without the other in terms of implied consent or implied trust, you can get yourself in trouble. I don't want that. You don't want that. So for now, I just want you to focus on these two types of trust. Okay? These are the constructive and resulting. Now remember, these are implied trust. Okay? So we're going to go back and we're going to go here. Okay? So we have the implied trust. Not the implied consent, but the implied trust. Okay? And it says, an implied trust is an element of trust law and refers to a trust that has not been expressly created by the settlor. There are two types of implied trust: resulting trust, constructive trust. So let's go here. Resulting. All right. Actually, I have it here. So all right. A resulting trust is the creation of an implied trust by operation of law, where property is transferred to someone who pays nothing for it. Then it is implied to have held the property for the benefit of another person. All right. So, this is a resulting trust. Again, is when property is transferred from one to another without consideration and will be deemed to be held for the benefit of the transferor, generally. All right. So let's make this simple. If a father transfers his house to his son, even without a trust document, okay, that is a resulting trust. So if you are a father and you give your son your house, you don't have to draw up any documents. All right, you just transfer it to him. What happens is, by law, there's a trust formed, and you're the grantor as the father. Not only are you the grantor, you're automatically the grantor and the beneficiary. Why? Because if your son has your house, it is assumed that you can use the house beneficially. Your son's not going to not allow you to live there, right? You gave him the house. If you sell the house, more than likely you're going to break your father off with some of the profits from the sale, right? So this is what they're talking about when they say resulting trust. When they say that the property is transferred from one, the son, to another, the father, without consideration, meaning the father just gives it to him, and it will be deemed to be held for the benefit of the transferor, meaning it's deemed to be held for the benefit of the father. He gave it to his son. He doesn't necessarily have liability, but he can still reap a benefit from that. Okay, this is a slick way that they can judge a gift or a transfer to mean that the person who gave it is giving it to the recipient and trust, and therefore they can assume that the giver is going to reap a benefit from it, and therefore they can charge you according to that in other types of laws. All right, I hope I made that clear. So again, we'll go over that. If a father transfers his house to his son, even without a trust document, there's a resulting trust where the dad can use the house to his benefit, be it by occupation, profit from sale, or rental, because his son, the transferee, is amenable to his father's needs, or he's going to cater to his father's needs. He's going to benefit his father with use of that house, or use of the proceeds from sales of that house. All right? That is a resulting trust. No documents needed. All right. So now, when we go back, remember we had what do we do here? All right, so we're going to go to constructive trust. First, let me pull back up this implied trust, because it's important that we see both versions. Okay, so that was a resulting trust we went over, right? Where the property is transferred to someone who pays nothing for it. All right, that's the resulting. Now let's go to the constructive trust. All right, now these are both types of implied trust. Remember that, keep that in mind. And you can think of implied just by the fact that it's not expressed. It's not these trust formations are not written down. They just happen because of the way things transpire. All right. Constructive trust is an equitable remedy resembling a trust imposed by a court to benefit a party that has been wrongfully deprived of its rights due to either a person obtaining or holding a legal property right which they should not possess due to unjust enrichment or interference. That one's a little more tricky. All right, but we'll explain that. All right. So, again, a constructive trust is one in which a remedy can be given for a wrong action by a court or arbiter. For example, you get your car towed by a company who may have had the right to tow it, but who acted in a way that was evident to be malicious, or somehow they were unjustly benefited from taking your car. So what happens? The judge can use equitable remedy, all right, or equitable rule, and order that the tow company return your car, all right, based on the fact that it was deemed that they unjustly took it under malicious premises, or they enriched themselves from it, which is what should be done in most cases. But they're getting paid for it, all right, and that's unjust enrichment. Now, the reason this is a trust is because, remember, your car is registered to the state, and the judicial system, i.e. that judge, is a trustee of it, you see? So again, we see why they can take it or why they can give it back. But when that happens, if the judge were to, in your favor, order them to give your car back, that is a trust. That is the evidence of the trust that the judge is the trustee of it, and the judge has ruled in your favor under equitable law, under the law of equity of trust, to return your property back to you, that your property was unjustly taken. Okay? This gets kind of convoluted, and I'm going to leave it there on that note, as far as the constructive and resulting. But if you remember nothing else, you want to go to those wiki links and read those articles, read those pages a few times. Trust me, this does not come easy. It did not come to me that easy. And I'm not going to limit anyone's intelligence to mine. So maybe you may get it easy. But if you don't be shocked, because people that I study with, the same thing. It does not come that easy, because if you're not familiar with the law, first of all, there's a lot of confusion involved in it. All right. So now we covered implied trust, right? Implied trust, not implied consent. We covered implied trust, which come under constructive or resulting. Now, here's a tricky thing. In another definition of implied trust, right, it is a trust that is imposed by law into certain situations, either by presuming an intention of the participants to create a trust or simply because of the facts at hand. All right. Now, this to me falls under implied consent. Implied consent is consent which is not expressly granted by a person, but rather implicitly granted by a person's actions and the fact and circumstances of a particular situation. Okay? In some cases, by a person's silence or inaction. Okay? This is very, very important for you to understand, family. All right? Implied consent. So now, we're going to go to our study of implied consent, and we're going to give the breakdown and an example. All right? Right here. Implied consent is an action that can form a trust. Okay? Now, I say trust because although trust law will not directly delineate implied trust as implied consent, they are one and the same, because what happens is an agreement is formed. That is a trust. Okay? That is a trust. And the other person who that agreement is informed, or who that agreement is formed with, whether you want them to or not, whether you perceive it or not. Remember, we said these implied trusts can happen without your perception. Whether you perceive it or not, they then have a certain usage of your property. Let's see how. So, implied consent is an action that can form a trust, one in which your actions signal an agreement to the terms being presented to you. For example, bear with me, fam. All right. For example, if a cop pulls you over, and in the course of questioning you, that cop says, "I'm going to search your car," and you ask why, and he gives you some answer like, "Well, I fear you may have weapons, or I smell marijuana," whatever the case may be. All right. So therefore, I'm going to search your car. And you say to him, "That's not right. You're harassing me." And while you're complaining, he's searching your car. All right? Now, even though you may not agree and you protested, all right, you did not expressly state your refusal and objection to the search. Okay, in law, the cop now has a legal right to search your car because you did not express your trust to his implied trust. See, he formed an implied trust with you, and you did not rebut it with an express trust. You did not say, "No, I do not agree to you searching my car. I do not consent to that." And what he did was trick you by forming his question as a statement by saying, "I'm going to search your car." Because let me tell you something. If a cop is going to do something, they're not going to tell you. If they have the right to do something without your consent, they're not going to announce it. Okay? So, even though you may not agree, you protested by saying that's not right, so on and so forth. That is not express objection to their proposal. And in the law, they can legally search your car with your now implied consent, resulting in a court case if that should happen, if they should find something. Because that's the first trust that was developed. Now it goes to the larger trust, which is the court. And they have jurisdiction over you because you have a driver's license, you're a U.S. citizen, so on and so forth. So this is all interminglings of trust. Okay? There's a trust to establish contact and contract, and then there's a trust to administrate. That's the court. The trust for the contact and contract is the cop, is the search, is the attainment of evidence as far as they're concerned. That pulls you into court. Now the court can administrate, seize your property, hold you, hold your property, hold your car, fine you, fine the trust. Now the trust has to pay. Okay? So I hope I made that clear. As I said, this is one of those instances where the trust law gets a little tricky. But trust me, diligent study, reading things over more than once, that helps a lot. It can all be you can figure it all out. All right. So that is the implied consent, which is close to the implied trust. But again, remember, in law, you won't see implied trust as implied consent. You'll see implied trust as either constructive or resulting. All right. Go over that a few times until it becomes clear. And we already went over express trust. I think enough basically as the peripheral for these other trusts, but we'll go over it again. Excuse me, fam, I have a cold. All right, express trust. Stated, written, and express trust is one in which the terms of the agreement are clearly written and spelled out on paper or verbally. All right, and remember, an express trust trumps an implied trust. That's another important thing. That's why in the example of the car, I said you did not express your trust properly, and that they would have trumped his implied trust, because now he has to go to another level once you refuse consent. Now he has to place his evidence and his probable cause on trial. Should it go to court, he has to vie his probable cause against whatever evidence or whatever reason you have to not consent to the search, or whatever claim you make in terms of being violated. All right. So express trust, clearly written, spelled out on paper. The terms are now express. Express trust have more power than implied trust in a court of law and upon presentation of the expression. For example, if you and your spouse separate and they say you can have the car, all right, when you both decide to divorce, he or she tells the lawyer they want the car. Now, that written express request is what the judge is going to hear. The judge is not going to hear you and your spouse in court bickering about who said what that lawyer was told and what that lawyer writes down, and what happens in the arbitration between you, your lawyers, between the spouse and the spouses and the lawyers. That is what the judge is going to hear, because those are express trusts. All right. There's no evidence of your verbal trust once the other spouse denies that. So that's just an example of express trust versus implied trust. All right, and how express trust will trump 99% of the times any implied trust. And the only reason I give that 1% is because, some courts they do some weird stuff. All right, so we'll go to the next page where we talk about the public trust and the private trust, and we give more of a breakdown on how those two are operated.